second keynote speech for the day. The topic is the Singapore IP Strategy 2030, Supporting Innovation and Enterprises. And may I please call upon stage Ms. Trina Ha, Chief Legal Counsel at Intellectual Property Office of Singapore.
Good morning, everyone, and I will try my best to be as entertaining and enlightening as Adrian. And it is my pleasure to speak here today to share with you on the work done by the Intellectual Property Office of Singapore. We call it IPOS for short. Adrian spoke about hiring the lawyer of the future. We hope to help you chart your future with IP. So very briefly, you'll see here on screen what the IPOS does. Besides registering IP rights like trademarks and patents, we actually also help develop laws and policies and build IP capabilities for the ecosystem. So it is actually very important that the officers in IPOS, from the legal team to the policy officers to those who deal with IT and grants, actually understand what are the technological advancements that are happening in our world, what are changing business models, and what are the new consumer trends. Because as Adrian said, technology is the answer to everything. And every age, as we all know, is one of disruption. From the 1800s, when photography was introduced, to photocopiers and VCR players, for those of us old enough to know how to use them, to the internet and 3D printing. And now we hear terms like the metaverse, NFTs, and of course, artificial intelligence. And though every age is one of disruption, it has been said that the age we live in now is one of constant disruption, because the advancement of technologies is so rapid. And they're not just pushing out new technologies, but new versions of new technologies. It used to be you have version 1.0, and then maybe a year you have version 1.1. Now you might have version 2 in 2 months. So this disrupts business processes, the way you operate, the way we ourselves as individuals, as consumers, purchase goods, the way we work, live and play as we move into the digital age. Now, I know during this two-day conference, you'll be touching on all these issues and the impact on businesses. And some of you, but not all of you, because there are quite a few IP lawyers in the room, will ask, so what's the importance of IP to all of this? And actually, it's really, really important, even if you do not actually see it, because IP underlies all the inventions and technologies that we create, from the coding produced by your AI system, to the contracts for purchase and selling NFTs, to how do you protect your brands in the metaverse. And even talking about environmental, social governance issues, ESG, IP is there. How do you create a sustainable IP patent portfolio that benefits the environment? So let me tell you a story. Earlier this year, there was a lot of buzz on the internet over the Euro 2.5 million, roughly US close to $4 million purchase by an NFT consortium. They're called Spice, DAO. They bought a very rare book of a failed adaptation of Frank Herbert's Dune. You will see on screen, I think the chairs might block it a bit, but I think you can see a copy of the book, as well as a tweet, where they spoke about what they intended to do with this book. They were going to create derivative works from the book. They were going to create NFTs of content from the book, because there were excerpts from film scripts, film stills, photographs, and they even wanted to create an animated series. And then they publicly declared that they would stage a burning of the physical book so that people would buy the NFTs. And then they would videotape the burning and sell the video as an NFT. So they were quickly schooled by the internet. They just have the book. They don't have the copyright to the book or the contents within the book. I see some of you nodding your head. I assume you're the IP lawyers. And so they were told that if they were to do whatever they intended to do, they would get sued by the real copyright owners. I just checked. They are looking for a seller of the book. So it's important for us to know about IP, what are the developments and the issues, and what is IPOS doing in this regard. Well, in April last year, we launched a 10-year strategy called the Singapore IP Strategy 2030 in how to strengthen the IP ecosystem, help the wider innovation community and businesses, and make us into a global Asia node for innovation, enterprise, and technology. I've put here on screen, sorry. If you are interested to read, there's a QR code of the report. So what you see on screen here is a summary of the three trusts of the IP strategy. And essentially, we are looking at strengthening our regime with progressive laws and policies, building IP capabilities so we have an IP-savvy workforce, and helping businesses, providing IP solutions to businesses. And I will be talking about three areas. The progressive IP laws, which I think you all will find interesting, how Singapore is an IP dispute resolution hub, and some of the services we offer to enterprises. Let's start off with the Singapore copyright law, which we have just updated for the digital age through introducing a completely new act, rewritten in plain English in November last year. In fact, Monday was the first year anniversary. This was a very comprehensive review that took around 5 years, and the changes are too many for me to go through with you, unless you have an hour with me. But you can scan the report and read about it at your leisure. But what I think might be of interest to you is a new statutory exception for copying of copyright-protected works and performances, specifically and solely for the purpose of computational data analysis. And we have actually stated in the Act what are instances of computational data analysis: text and data mining, sentiment analysis, and training machine learning. So, and our exception is not limited to only non-commercial use. We are silent, which means you can use it for commercial purposes as well. Copying the works includes storing or retaining the copy, but there are some safeguards. You must have lawful access to the work in which you want to make the copy. So, for instance, you cannot circumvent paywalls to access the copy. And the work itself must be non-infringing. For instance, if you are getting the work from a hub that is well known to have flagrantly infringing works, and that you're not doing it with a good conscience, the exception does not apply. And we have also provided, same as the UK, that the exception cannot be overridden by contractual restrictions. With this exception, we hope to encourage research and innovation, because AI needs a lot of large data sets to operate, to be trained, and we believe that because this is not a consumptive use of the copyright works. You're not watching the videos to enjoy yourself or looking at photographs. What you do is scraping the data or using the images or journals or publications to train your AI to produce something else. Another area I'd like to talk to you about is virtual designs. So a registered design protects the novel pattern, shape, configuration, ornamentation of a physical product. But increasingly, we are looking at virtual products, virtual designs which have no physical form and are created by immersive technologies such as VR and AR. So how do you protect these type of designs under our Registered Designs Act? They can be protected as a graphical user interface or as a non-physical product. And the Act defines a non-physical product as anything that does not have a physical form, is produced by the projection of the design on a surface or medium, including air. So you can project it into the air. But it must have an intrinsic utilitarian function that is not merely to portray the appearance or just to convey information. So if you can see, there's an illustration of a man interacting with a virtual panel to access information, edit information, perhaps print and email information. And for virtual designs that do not meet the criteria of a non-physical product, well, you can register it as a graphical user interface. For instance, when you wear a VR headset and the designs are displayed on the screen, not projected, but displayed on the screen for which you can navigate, that could be registered as a graphical user interface or perhaps a virtual analytics dashboard. we started looking at these issues back in as far back as 2014, and the laws were passed in 2018. And back then, we struggled a lot with examples. A lot of it seems so far-fetched. A virtual piano, an interactive dashboard that allows you to, print information, virtual remote control from which you can, set your aircon, lock your door, set your oven timer. But now, in 2020, it's not so far-fetched. And in fact, some of us feel maybe it's time to start talking to companies like you and see if we need to further update it for what is happening now. Now, let's move on to AI, right? So in 2019, Singapore published a national AI strategy, and it recognized IP as important in developing and commercializing new AI technologies, hence the computational data analysis I spoke to you about. But at the same time, that does not mean we should race to regulate AI and the works and inventions it creates. There's a lot of talk now on the internet, on LinkedIn, on Facebook. All the technology magazines are talking about, do we protect AI inventions? Should we give authorship to AI created works like paintings? A couple of months ago, there was an uproar because an AI-generated painting won a prestigious art competition in New York. But a game-changing development like AI cannot be seen solely through the lens of IP. We need conversations to mature, consensus to emerge between companies, industry, and even between jurisdictions, because we live in an increasingly borderless world. If something is protected in Singapore but not protected elsewhere, people might say, what's the point? So we need that kind of consensus to emerge. And the issues and its underlying policy considerations, even as far as going, does an AI have a legal right to own its invention? Well, this must be assessed holistically in the broad context of all the laws and regulations that touch on AI, looking at creation to even liability, especially for autonomous vehicles or products that may be designed solely by AI but could have consumer liability. So at IPOS, we are closely monitoring developments. We are talking to industries, we are talking to other jurisdictions, and we are engaged in the international conversation. And as mentioned on screen, we actually did a study with IMDA and SMU to hear from the ground the issues that companies, inventors have regarding not just IP, but data as well. And what is interesting is that it's just the first step. It's a conversation on how do we balance protecting the work, the output that you have heavily invested in versus open access that you need in order to create those works. Where does the balance lie? We don't have the answer, but it is certainly something that we should keep talking about. So now I turn to IP dispute resolution. Together with the Ministry of Law, IPOS seeks to position Singapore as a world-class venue for IP and technology dispute resolution. We are, of course, not the only hub that can do it, but we believe that some of the hallmarks that are attractive is our respected judiciary, global connectivity, and we do have world-leading institutions here, the Singapore Institute of Arbitration Center and the Singapore International Mediation Center. Unfortunately, my colleagues from these two institutions could not be here at this conference to speak to you because of conflicting travel schedules. That's how much in demand they are. But, and also the World Intellectual Property Organization, WIPO, has its Arbitration and Mediation Center based here in Singapore for the region. And the details of which are in the brochure. You can read it by scanning the QR code. But what I'd like to talk a little bit more is this scheme that IPOS has. It's called the Revise Enhance Mediation Promotion Scheme. Why revise? Why enhance? Because we actually started this 5 years ago and we've been enhancing it over the years. So what it means is that if you have a dispute before IPOS, a trademark opposition, right? A trademark invalidation, regardless of the mediation outcome, you can apply to IPOS for funding of up to $14,000 for the cost of the mediation. It will cover the service provider's fee, it will cover the mediator's fees, and it will cover your lawyer's fees and disbursements up to 80%. And it's regardless of whether your mediation is successful or not. All we ask in return, you allow us to appoint a shadow mediator, who is usually a young IP lawyer, to give them the exposure and training to dispute resolution, and to be publicly named if we issue any publicity. But of course, we would not reveal the details of the settlement. So please take a look and see if it's of use to you. And finally, what services does IPOS offer? Very briefly, I will just touch upon a few. We actually have a subsidiary called IPOS International, where we house close to 100 IP experts, from patent examiners to IP trainers to consultants, to provide the services you see on screen, focusing largely on training and education, as well as patent analytics. And in particular, let me introduce a new tool that they just created called Tech Insights Through Patents, or TIP for short. Now, patent data is increasingly recognized as an essential source for technology innovation trends and technical data, and which help shapes company strategies. There have been quite a few studies that show that actually patents contain more than 80% of all technical information worldwide, and most of the information cannot be found elsewhere. Around 90% of US, European, and Japanese businesses rely upon such patent information. And so we want to help enterprises do the same. And TIP therefore offers an interactive platform where users can select specific data points, culled together, analyzed, and organized by our patent examiners, leveraging on their patent search expertise. What you see on screen is the first study for this tool on AI. So it categorizes global AI patent applications according to countries of origin, market protection, and industrial sectors. And this would help companies, researchers to shape their R&D efforts and their decisions. Finally, if enterprises are still unsure how to manage or protect their IP rights, we actually have complementary IP and business clinics that help quite regularly. And there's a panel of lawyers and consultants you can choose from to seek advice if you are a Singapore citizen, PR, or your business is registered here. Well, that in a nutshell is what the Singapore IP strategy is about, and how we hope to work with businesses, creators, innovators. Now, the landscape is constantly evolving. We will, of course, monitor developments, but there is a need to have more engagements with businesses, practitioners such as yourself, even academics, to hear views from all perspectives from the ground. And this will help us policymakers craft legislation that is hopefully future-ready and able to withstand the rigors of technological development. So I will end my presentation by saying, please come and speak to us here at IPOS about the issues I just spoke about, be it you're wondering whether your design can be registered, how would I use the computational data analysis, how do I protect my code, as well as any other IP issues and concerns you may have. So thank you very much for listening to me, and I wish each of you a very fruitful and engaging conference. Thank you.